Hi, this is Jack Milligan with the Plaintiff's MSA and Lien Solution, addressing all of you attendees at the recent Trial Guides conferences at the end of June out in Orlando. Now, you may have seen this document, flyer, in your handouts or swag bag. And on this, we're talking about the fact that PMLS sells MSA avoidance. But an interesting thing happened. Lisa Carper from Trial Guide sent us an email and said, "You would not believe the number of attorneys that asked me what an MSA was and why it was a problem or concern." Well, we weren't aware that attorneys weren't aware of what MSAs are and why they can be a problem or concern, but I thought I should do a quick video and explain this. An MSA is a Medicare set-aside arrangement. An arrangement is the term the government uses. It covers all the various possibilities that a plaintiff coming through a personal injury settlement could use to prevent the Medicare Trust Fund from becoming a first payer in the future for the services related to treatments for the injuries or conditions that are the subject of the settlement that you have obtained for that plaintiff. Now, there is no legal requirement to create an MSA. However, it's interesting that Medicare has said that if a plaintiff has done absolutely nothing at all to protect the Medicare Trust Fund from becoming a first payer, then Medicare can take the position that your client's entire settlement is available to pay for future Medicare allowable treatments related again to the injuries or conditions that are the subject of the settlement you've obtained for them. Now, that's what an MSA is. It's an arrangement whereby your client has figured out some sort of pot or bucket or account where they can stash some money that will be used to pay for Medicare allowable treatments related to their injuries or conditions that are projected to occur over the rest of their life. But here's the really interesting thing you need to know as to why a plaintiff would do this if it's not legally required, and here it is. And I stated this earlier. If Medicare discovers that a plaintiff has done absolutely nothing in the way of trying to protect the Medicare trust funds from becoming a first payer, and Medicare can then take the position that your client's entire settlement is available to pay future medical, which means, and Medicare has said this, the client would have to expend the entire settlement or its equivalent on future Medicare allowable expenses before Medicare would jump back in and pay for those same services. That is just, for most plaintiffs, that's an untenable position to be caught in. And so why would these plaintiffs voluntarily create a Medicare set-aside arrangement? Because properly constructed, it would enable that plaintiff to set aside in a vehicle of their choice a much smaller amount of money than the entire settlement. Now, how does that happen? Well, there are experts in this country, and our company is one of them, that can perform the analysis of your client's life care plan if it exists, but definitely the prior 2 years of their medical records. And that analysis projects forward all of the services related to the treatment that your client will most likely need, based on their doctor's opinions, for the injuries or conditions that are the subject of the settlement that you've gotten them, that are also, and this is key, Medicare allowable. That's what we're talking about, is just the Medicare allowable future expenses. Because Medicare says they're a secondary payer behind the client's settlement. That is the law since 1980. The Omnibus Reconciliation Act of 1980 made Medicare secondary not only to workers' comp, which it was secondary to workers' comp from the addition of the 1965 Medicare Act, but in 1980 they added language that made Medicare secondary to all forms of insurance and insurance settlements. So it's been there since 1980. There's nothing in the code that says that anybody has to create a Medicare set-aside, and that's because the government believes that plaintiffs should have the choice as to whether to put money aside or not. If you don't put money aside, again, Medicare takes the position that the entire settlement is available for future medical, and what's going to be required is that your client pay for all of those medical treatments out of pocket. Now, to avoid being put into that situation where the client has to, your client has to spend their entire settlement on future medical before Medicare ever steps in to help them out, you hire a firm like ours to do an allocation study that creates the report that says we've identified the following treatments and the following services that are Medicare allowable related to your client's injuries projected out over the rest of their life. That number is almost always a small fraction of the overall settlement. Now, here's the other part of this. The government has also opined on ways to avoid having to create an MSA. And I've created the definitive guide for doing that. It's the Insider's Guide to Avoiding an MSA. And that is also what's included in this flyer. And you can click on one of the links in this flyer or put in our address to obtain that Insider's Guide. But it will give you the information and the background on avoiding an MSA. In our world, the best plaintiff's MSA is no MSA. Our goal is to help your client avoid having to put any money aside from their settlement into some sort of segregated account. That could be a bank account, a separate checking account they maintain. It could be a Medicare set-aside account administered by a firm like ours. It could be a coffee can that they put a certain amount of cash into, advised again by an allocation firm like ours as to how much to put in there. And that coffee can labeled Medicare bills only and used only for Medicare. The idea is that with absent any arrangement, then unfortunately there's the potential that Medicare could take the position that your client must spend all of their settlement on future Medicare allowable expenses before Medicare steps in. So what's the positive here? Well, for clients that voluntarily hire us to first help them try to avoid this, but if we can't, 2/3 of the time we can, but for 1/3 of the case assignments we get, there is some amount of future medical that is going to have to be paid by the client, and we identify that amount. Again, it is usually a small fraction of the overall settlement, but here's the beautiful thing. Once that amount is set aside and then spent on Medicare allowable expenses related to the injuries that were released in the settlement, at that point, an exhaustion letter goes into Medicare to tell Medicare that your client had money set aside and that set aside is now empty. It's exhausted. By law, from that point forward, Medicare has to cover your client for all of their Medicare allowable needs, including for the services related to the injuries or conditions that were released in the settlement. So essentially, the idea is you've got an entire settlement over here, a much bigger amount of money that your client could be required to spend, or on this hand, you've got a much smaller amount of money represented by a recommended minimized MSA allocation that when the client has spent this smaller amount of money, Medicare steps in and starts paying their bills. Which would you prefer? That your client have to spend the entire settlement before they get into Medicare's pocket? Or that they set aside a much, much smaller fraction of their settlement, and once that's exhausted, all of their bills now go to Medicare, and Medicare by law has to pay them for the rest of their life. Hope this helps explain what an MSA is and why it could be a problem. I understand that trial attorneys are very sensitive to any dollars coming out of a client's settlement that reduces the net to the client. It causes unhappy clients. We have devised a way to help plaintiffs avoid this legally without impacting their future Medicare benefits and without creating a long-term liability for plaintiff attorneys. That's you, of course. And then we also have created the services for those clients, that 1/3 or 33% that were not able to help avoid this. We've created the services to help them minimize it to the absolute rock bottom dollar that is reasonable and defensible. This has been Jack Mulligan for the Plaintiffs MSA and Lien Solution. We'll be talking to you again soon.